How much free speech do we really have at school? This has been a controversial issue for more than half a century, and several court cases have gone through trying to answer that question once and for all. Our first case, Tinker vs. Des Moines, sets the precedent for students' free speech. In showing support for a truce for the Vietnam War, several students decided to fast for 2 days, December 16th and January 1st, and wear black armbands in the days between fasting. On December 13th, the principal of the school announced that anyone wearing a black armband on campus would be sent home and suspended. On the 16th, one student went to school wearing an armband and was suspended until January 2nd, the day after the protest was planned to conclude. The Supreme Court ruled in a 7-2 decision the school's restriction on armbands violated the students' right of free speech. They made it clear that students do not lose their First Amendment rights when they step on school property and retain their right to political speech. But while they supported the court's decision, Justice Potter Stewart said that he did not believe that children are necessarily granted the full extent of the First Amendment, and Justice Byron White said that the First Amendment only states that the use of freedom of speech is specified as verbal and not necessarily by actions. Justice Hugo Black, one of the two justices opposed to the decision, also pointed out that the First Amendment does not grant the right to express opinion at any given time. He continued to argue that the school has the ability to follow through with their punishment if the student was distracting other students from their work. However, his opinion was overruled by the majority of the court.
Our second case, Bethel School District versus Fraser, would test the extent to which the Tinker case protects the freedom of speech for students. During a school election at Bethel High School, one student named Matthew Fraser gave a speech about his fellow student and included a graphic sexual metaphor in hopes to promote his campaign. His speech went like this: "I know a man who's firm. He's firm in his pants, he's firm in his shirt, his character is firm. But most of all, his belief in you, the students of Bethel, is firm. Jeff Kuhlman is a man who takes his point and pounds it in. If necessary, he'll take an issue and nail it into the wall. He doesn't attack things in spurts. He drives hard, pushing and pushing until finally he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. So vote for Jeff for ASB Vice President. He'll never come between you and the best our high school can be." This speech violated Bethel High School's policy on obscene language. Therefore, Fraser was suspended for 2 days. Fraser filed a lawsuit against the authorities claiming a violation of his First Amendment rights. At the district court, only one judge ruled in Fraser's favor, but he appealed. The U.S. Ninth Circuit Court of Appeals reversed the previous ruling done by the district court. After the school district sent the case to the Supreme Court concluded that the First Amendment did not restrict a school from disciplining a student that violates their policy on obscene language. Justice Berger noted that political speech and Fraser's sexual metaphor were not the same form of free speech. Therefore, his vulgar language was not protected by the Tinker vs. Des Moines ruling.
Our final case, Morse vs. Frederick, would again test the limits of free speech at school. At a school-supervised event, a student named Joseph Frederick held up a banner saying "Bong hits for Jesus." Principal Deborah Morris confiscated the banner and suspended Frederick for 10 days. Frederick argued his case in the district court, saying that his First Amendment rights had been violated. The court ruled in favor of Morse, finding no constitutional violation, but the U.S. Court of Appeals for the Ninth Circuit reversed their ruling, citing Tinker vs. Des Moines, which extended the First Amendment rights to students at school except when that right would cause a disturbance. Frederick was punished for his message, not any disturbance, so they decided that his punishment was illegal. So can a school punish students for expressing pro-drug messages? Apparently, yes. The Supreme Court ruled in favor of the principal in a 5-4 decision. Chief Justice Roberts' majority opinion held that students' political right to free speech at school does not extend to pro-drug messages because they may undermine the school's mission to discourage drug use. Justice Thomas also added that the right to free speech does not extend to students, and wishes to see the ruling of the Tinker case overturned entirely. Although the cases answered some of the questions surrounding free speech at school, It is still somewhat of a controversial topic, and the laws regarding it are not clearly defined. One thing is for sure, however, free speech for students is much less inclusive than free speech for adults.